One of the things it raises is the question of we develop a statute and it's really a one-size-fits-all. But the thing that raises a question in my mind is whether or not inner city Houston ought to be treated the same way as Canadian Texas. I mean, and whether regional considerations ought to play a role, because what may be good in Canadian Texas may not be good in Fifth Ward, Texas, or best interests of the child may be considered one way in one area versus another area. And I know we're getting into the weeds on this, but should the legislature even? I mean, it's not going to go away if we do nothing.
Correct.
The question is not going to go away if we do nothing, and it's going to get. I project it's probably going to get a little bit more, rather than getting better. It'll get less better, not worse, but less better. And I'm not sure what that means for us as policymakers, whether we ought to stand up and say, well, recognizing it's difficult, here's what we can do or say about it. And I'm not sure how to proceed in it, because I recognize that best interest of the child generally is considered, and I mean generally talked about in terms of access to the child. But it also applies, I think one of you mentioned, to child support, for example. Should you consider best interest of the child, and is it the same standard when you're looking at child support versus access to the child? I'm not sure whether the Holly factors even make a distinction, or whether or not there's something else that governs when you're talking about one situation versus the next situation.
Well, and that's go ahead. No, go ahead.
I think what was so brilliant about what Representative Cook's bill was working on last session was it didn't get into all of the things that we've been discussing here today, all of the variations and how this might appear in a custody case versus a modification case. It really started from what are the foundational principles that we know and expect to apply? How should every family be treated when they walk into a courtroom? And that's the guidance that we recommend and that Representative Cook's bill was working on providing, right? Providing that set of standard principles that every family deserves will help in addressing some of these cases that have caused us to come into this room today. You know, CJC is a prime example. One of the reasons CJC happened was because the judge had a different opinion of what was in the best interest of the child than the child's fit, loving father, and found a way to get around what you all had already put in statute to get the outcome that judge thought was best. Now, fortunately, it made it to the Texas Supreme Court, and the Texas Supreme Court overturned that decision. It cost that father a lot of money. It cost that father a lot of time and a lot of heartache. And that's one example of, I think, why having that baseline starting point for best interests that is in the code that you can point to, rather than having to go to all of these different sources of case law that says this is where the judge has to start from when they're faced with the best interest determination, right? Because otherwise you can get into these decisions. We talked about, sports earlier, right? Fit parent, if they want their child to play one sport based on constitutional principles, the court can't come in and say, well, we don't think your child should play football because of the risks of head injuries and all of these different things. We think they should play soccer, right? If the parent is fit and they're making that decision and there's no danger of harm to the child, then the court should not be able to make that type of a decision. Now, that's a very simplistic example, but I think it illustrates the fundamental principle that we're talking about.